Looks like it's working. Good afternoon. My name is Charity Ryerson, and I'm the co-founder of an organization called Corporate Accountability Lab. And I'm here today to talk to you a little bit about an e-course that we're hosting in January on business and human rights. I'm going to talk about it for about 30 minutes, but while I'm talking about it, I want everyone to feel free to post comments or questions below the video feed. I'm happy to respond in real time. This is supposed to be interactive, so feel free to interact and to ask any questions that would be helpful for you to discern whether or not this course would be helpful for you and your career. So this course is co-hosted by Corporate Accountability Lab and Ankawa International. You can learn more about our organizations. Corporate Accountability Lab is at legaldesign.org, and Ankawa International is at ankawainternational.org, but it's internacional with a C and not a T. So there you can learn more about our organizations, get a sense of where we're coming from for this course, and you can also, on Ankawa's website, you can register for the course and get a full curriculum of what we plan to cover during the course. So this course is geared toward a pretty broad range of folks, I would say. So while I'm an attorney, my co-professor, Elizabeth Umlas, is a PhD in political science. So we're coming at it from an interdisciplinary perspective. And so we're trying to make this course accessible, not just to, practicing attorneys or people in this field, but in fact, it's more of an intro course. So if you're a law student, this would be perfect for you. If you're a practicing attorney, but in a different field, so you haven't had a lot of exposure to business and human rights, this would be a great opportunity. Also, folks that are totally outside of the legal field who might be human rights practitioners doing field work or working in NGOs, doing policy work. I think anyone in any of those categories would benefit a lot from this course. Business and human rights as a field is something that is ever changing. It's a really fascinating and growing field of law and practice. There's a lot of reasons for that, but I think that the obvious one is that corporations are increasingly working transnationally, and that raises big questions about how the global economy is structured, how our legal systems handle transnational activity when we primarily handle legal accountability in domestic legal systems. So when something becomes transnational, how well is the international system suited to handle that? So in the past, and how does it seem like it's evolving to do so in the future? So it's a very dynamic field, and if it's something that you're interested in pursuing a career in, I think this course as a 2-week intensive is really an extraordinary opportunity to get a deep dive into this field that I think you wouldn't necessarily have an opportunity to in a lot of academic or professional environments. I also think that because of the range of professors that we have in this course, that also makes it particularly unique. So in addition to Dr. Umlas and I, Amilcar Romero from Ankawa International is going to be participating in the course, and Charles Wiwa, who is a member of the Ogoni community of the Niger Delta, and I'll talk a little bit more about him, but he'll be sort of representing an affected community in the course and having an intervention as well that I think is really going to be helpful for us to frame this not just in a kind of ivory tower academic way, but to be able to really include the voice of an affected community. We're going to be taking that case of the Ogoni in the Niger Delta and using that as a case study for the course in general. So while we will be looking much more broadly at the field of business and human rights, we're going to focus in for a couple of sessions on the situation of the Ogoni and their struggle for justice with Shell, which I'll speak a little bit more about. So I'd like to just go over some of the topics that we're going to be discussing in the course to give you a sense of what the breadth and what our vision is for this course. So we will definitely delve into a lot of the international standards that are developing to address issues in this field. So in particular, if you're not familiar with the UN Guiding Principles on Business and Human Rights, these have evolved as the main standard that's being used. Now, it's a very general standard, so it doesn't provide very specific information about how to implement human rights norms in the business context. It really just gives overarching principles. And so with overarching principles, what do you do with that? So it raises a lot of questions. There's a lot to discuss there. The UNGPs, they say that it has a protect, respect, and remedy framework, or a 3-pillar framework. And that refers to the state duty to protect human rights, the corporate responsibility to respect human rights, and then access to remedy for victims of human rights abuses. So a lot of the course is going to fit into, in one way or another, those 3 pillars of the UNGPs. So we will be talking about human rights due diligence, meaning, I think sometimes when we think about human rights abuse, we often think of what has already occurred. So due diligence tries to look at it from the other side and say what kind of mechanisms should be in place to prohibit the violation of human rights, and what is an effective way to, when human rights accusations of human rights abuse are happening, how are companies responding, and what are their internal policies to deal with that. That's a very, I would say, in motion area that is very interesting, and for folks that come at this from a perspective, I think this might be the part of the course that would be of greatest interest to you. So if you're working within a corporation and you're thinking about how to get your head around the broader human rights and business debates, I think that the issues around due diligence and what corporations can do ahead of time to prevent participation in human rights abuse, it could be very valuable. We'll be talking a lot about access to remedy. So initially we'll talk about access to remedy in terms of non-judicial mechanisms primarily. So looking at the ways that, for example, there's a lot of different strategies that have been used in the broader human rights movement, corporate accountability movement, et cetera, to deal with some of these issues. And because law has not been as effective as it could be, or as I think folks might think it is, there's been a lot of other types of initiatives that have been developed. Socially responsible investing as an example, international labor rights monitoring, codes of conduct. There's the list kind of goes on and on. So we will touch on some of those just to kind of get a sense of what's happening outside of judicial processes. We'll also look at I would say, sort of quasi-legal areas like OECD complaints. The OECD has a grievance mechanism for victims of corporate human rights abuse to bring complaints to the OECD. So we'll look at some of that and how effective that has or has not been historically, and kind of what the potential may be there. We'll focus a little bit in on extractive industries in general. I think that probably, as most people know, there's a lot of human rights implications in the extractive industries. They tend to be in conflict zones. There's land rights problems. There's, issues of just who should own the natural resources of a country, and that has human rights impacts. So we'll look at that specifically. And then we'll shift over after that to look more at some of the, traditionally legal aspects of the business and human rights field. So that's more, where I'm going to come in. I'm a Alien Tort Statute litigator. I've done Torture Victim Protection Act litigation, different types of legal work on behalf of victims of human rights abuse. So we'll be looking at not just in the United States. So, as a U.S. litigator, obviously that's my area of the greatest expertise, but we'll be looking at it in the international system. So what countries have existing laws that allow them to deal with harm? And just to kind of preview what the broader issue is there, it's that, traditionally the international system has not seen corporate actors as a subject. So, if you even think historically about the human rights field, we think about states as being the primary violators of human rights. And so the international system and international courts, regional human rights courts, have primarily dealt with state sponsored or state allowed, or the role of the state in the abuse of human rights. So when you get to corporate liability, it's much more patchwork. So there are some courts that have accepted corporate liability, though most have not. And when they have, the role that they're able to play has been very limited. So that means that domestic legal systems would be the natural place where these sorts of cases would be dealt with. But because of jurisdictional issues, a lot of those domestic legal systems have rejected these cases, leaving a gap between the international system and most domestic systems. And so what do you do when you have a transnational company that's based in the global north, commits a human rights violation in the global south, and there's not any legal system along the way that's able to address that and provide remedy to the victim? So that's kind of the overarching problem that faces this field and what all of us in the field have devoted our careers to working out how to solve it. So, with that, we will look particularly at a few cases in a few countries in Europe, possibly a few cases looking at how crimes are handled in the countries where they occur, insofar as that's possible, which there's a lot of variation there, and that's also a very interesting topic to talk about. And then we'll also look at, here in the United States, the Alien Tort Statute, the Kiobel decision, which for anyone who's in the human rights field, or if you're familiar, you're probably aware that in the last few years, human rights law within the United States, insofar as we practiced it here, has really had some major hits through some bad Supreme Court decisions. And so we'll talk a lot about what that has meant, both for human rights law in the US, but globally, what the broader implication of those decisions are. Now, this case is particularly interesting for us, this Kiobel versus Royal Dutch Shell case that changed the law in the United States, not just legally, but also factually. So this case is, it takes the issue of the Ogoni people, and that's what came before the Supreme Court. And I think that here in the comments, we've just got posted Charles Wiwa's podcast on Shell's impact in Ogoni land, so that's great. The impact of Shell in the Ogoni land is something that is extraordinary, long-standing. Shell entered the Ogoni land in collaboration with the Nigerian government in the 50s without the permission of the Ogoni people, which is a traditional, it's a tribal community that has collective land ownership. And through some changes in the law in Nigeria, they had various ways to justify Shell's drilling on their land. Over time, the land was destroyed through oil spills, gas flaring, contamination of the water supply, contamination of the soil that made it very difficult to grow crops. It brought violence to the community. Many people have fled. And so we've been in a project, Ankawa and Corporate Accountability Lab, with members of the Ogoni community to think about different kinds of legal options that might be available following what happened in the Kiobel case, where their claims were dismissed basically on jurisdictional grounds because of this broader legal problem of the gap between the international and domestic legal systems. So that case is illustrative in many ways. And I think that it's a really exciting one for us to be looking at right now, not just because, the harms that the Ogoni have suffered have been so extraordinary, so long-standing, and the problem is so complex that it gives a lot to consider when we think about how to effectively handle these problems in a global system. I think that there's other cases that are much simpler, and while that would be interesting, it doesn't give us the same amount of opportunity to delve. The other thing that's very interesting about this case is that the Ogoni people have pursued recourse in courts across the world. So they've filed cases in not just the United States, but in the United Kingdom, in the Netherlands, in Nigeria, and African Commission. They've filed OECD complaints with Amnesty. They've been extraordinarily activist and aggressive about trying to find some kind of remedy for the harms that their community has suffered. And some of these efforts have been successful, particularly in the United Kingdom. There have been a couple of successful cases that have provided reparations to some small portion of the community. So in that sense, it's been a very patchwork process. But there are still hundreds of thousands of people in the Ogoni lands who have suffered very serious harms and have never been provided any kind of remedy. Because of that, and because of its significance in sort of ending the Alien Tort Statute in the United States, this case is very ripe for innovation, in the sense that as we think about what to do about some of the problems in holding corporations accountable, and also just in general in providing business and human rights guidance to corporations to avoid these problems, the Ogoni case gives us a lot of meat to dig into in what sorts of problems can happen and how complex they can be. So we're really excited to have Charles Wiwa joining us for this. Charles, he was a plaintiff in the Kiobel litigation in the United States. He is from a part of the Ogoni lands, from a community where Kensera Wiwa, who is a relative of Charles, was killed. Kensera Wiwa, if you're not familiar with him, he's been called the Martin Luther King of Nigeria. He was a activist and playwright and speaker, and just a really extraordinary movement leader who had been protesting Shell's operations in the Ogoni lands, and as a result of that was falsely accused by the Nigerian government of crimes, and then was executed along with 8 other members of the Ogoni community. This gave rise to a lot of litigation, and that's part of the human rights litigation related to the Ogoni situation, and then the other part is related to the extraordinary contamination of their land. The fact that the WHO did a public health study or an environmental study there. UNEP did an environmental study there and determined that there were very high levels of contamination of the groundwater. And that means that right now the kids that are growing up in the Ogoni land are drinking contaminated water with high levels of carcinogens. And what is the generational impact of that? And how do you remedy a harm that was not to just, in this case, the Ogoni 9, but actually affects generations of members of the Ogoni community? So I think that that's going to be a really, interesting and unique opportunity. I think if you typically take a human rights and business course at an academic institution, you rarely get to have this kind of direct work with a member of an affected community. And I think that by taking this as a case study, the participants in the course are going to have a really unique ability to understand these issues and to see how complicated it can get, but then that will, obviously make them more able to enter into this sphere. So that's a basic overview of what we're going to cover in the course. I don't see any questions right now, so I'm going to turn to talking a little bit about the just the details of the course itself. So it's going to run from January 8th to the 22nd. It's 2 hours per day, so we're going to do it on Chicago time from noon to 2. So, wherever you are in the world, that's Central, U.S. Central time. For some folks, depending on where you are, that may be a very inconvenient time. If you're in the United States, there might be a way, if you have a full-time job, to be doing it during a lunch break. If you're in Europe, it's not going to be during the workday. If you're in Asia, this could be in the middle of the night. So while it's certainly our preference that people would be able to participate in the course as it's happening in the lectures in real time, so that you can, pose questions and we can answer them and really be engaged with you just as we would if you were in a classroom with us. That would be our ideal. At the same time, we understand that this is open to people across the globe and are sensitive to that. So while some of the evaluation of the course will be based on participation, it doesn't have to be participation in real time in the lecture, but we would like participation online on the forum on the website of the course. And there will be, if you want more information about the technological infrastructure of the course and how all of that works, that's also either available on Ankawa's website, or there's a place to contact them to ask you more specific questions about how that works. So on evaluation, 80% of the score will be based on a final exam. The final exam will be held on January 22nd. We're planning for that to be a 2-hour exam with 20 questions, 10 questions related to the first week of the course and 10 questions related to the second, and then 20% on participation in the sessions and in the forum. Otherwise, maybe just to note that for folks who participate in the course but are not able to achieve a passing grade, which under Ankawa's academic standards, that's 1420 on the exam, but I think that's weighted on the with the participation otherwise. Then if you are not able to achieve that, you would just get a certificate of participation, and otherwise you would get the official certificate of passing this course. So, just to be clear, this is an academic course. It will be academically rigorous. There will be readings. Those readings will be available ahead of time. So it's in a very condensed time frame, but we're sensitive to the fact that people have jobs and academic schedules. And so we will provide the readings in advance of the course beginning. And so we'll have assigned readings for each date, but hopefully, if you have scheduling issues, you would be able to do all of those readings before the class starts. And we're also, I think, just want to say that we're flexible and happy to work with folks to make sure that this works with your schedules. We understand that it's unique to do an international course like this, though less and less so. They're becoming increasingly popular. But we think that this is really an extraordinary opportunity for folks to get an introduction into this area of law and practice. And so we really encourage people to approach us with questions. You'll see over in the comments, I think that Ankawa just posted an email address, info@ankawainternational.org, which you can use to ask any specific questions about the course or the technology evaluation, etc. Also on ankawa.org, or ankawainternational.org, excuse me, there is a full detailed course description, day-by-day breakdown of the topics that we'll be covering during the course. So if you need additional information, there's plenty there. There's also some additional description of this on the legal design on the Corporate Accountability Lab website, which again is legaldesign.org. I also encourage you to look at those websites to see the bios of Dr. Umlas and myself, of Amilcar, and I think that will help give you a sense of all of our perspectives on this course. So if there are not any additional questions, let me make sure that that's the case. I think there's no more questions. Thank you for your time, and I really look forward to working with all of you in January.